it's time for us to get back to reality, because you know what? You all can stay over there and keep peeping at DJT and that debacle with his boy Epstein, but we know the deal. We know the drill, and that drill is one agency that the Supreme Court couldn't get rid of, although they, clamped down on Chevron deference, although they clamped down on Humphrey's executive, but the agency that's riding high and baby getting a lot of notice is the PPP, and that's the Pied Pipers of pedophiles. And as they say, they not like us, and a minor, so I will continue on. Now let's move over here to Clarence Thomas, intentions on voting. Justice Clarence Thomas has consistently advocated for narrowing and even dismantling significant portions of the Voting Rights Act, particularly Section 2, which prohibits racial discrimination in voting practices. Thomas' position, developed over several decades, is rooted in the belief that the VRA has evolved into a mechanism for regulating, rationing, and apportioning political power among racial and ethnic groups, rather than simply eliminating discrimination in voting. He has argued that the current framework exacerbates, which makes it worse, racial tensions by creating a consciously segregated districting system, and has criticized the judiciary involvement in redistricting and unnecessary entanglement in political affairs. And that's more like what's going on with the redistricting with the maps in what?
In Texas.
Shout out to you, Jasmine Thomas.
Jasmine Crockett.
Ooh, I know she said, back up, sister. That was a Freudian slip, Jasmine Crockett. Because my boy was on my mind and I didn't mean to bunch his name over there with yours. Ooh, that was horrible. But my apologies to you.
My apologies to you. We don't want to disgrace your name in front of Stambo.
Okay, in his dissent and opinions, Thomas has repeatedly stated that Section 2's requirement to consider race in the drawing of districts is conflict and constitutional principle, particularly the Equal Protection Clause of the 14th Amendment. Taking away all those amendments. Now, what he done got rid of already? He done got rid of what?
He got rid of Section 5, and he's undermining Section 3.
And now he coming for 2.
Yep.
And then the 14th Amendment. He has called for the Supreme Court to reassess or even declare Section 2 unconstitutional, expressing hope that the court will soon recognize that he views an untenable conflict between the VRA and the Constitution. Ooh, deliver us from evil. Recent signals from the Supreme Court, such as interventions in Louisiana and Alabama redistricting cases, suggest that Thomas' long-held views may now be gaining more traction among his conservative colleagues, potentially leading to a significant rollback of Voting Rights Act protection, especially those that account for race to secure minority representation. A black man. Can you believe that? Well, he ain't never been black. I'm sorry. No representation. And look who's leading the pack. Ooh, I know.
Thurgood Marshall is rolling in his grave right now. And you know who else is rolling in his grave? Malcolm X is rolling over his grave. And I know we beat Bell Barnett. And all these guys will be rolling over their graves, seeing who Clarence Thomas.
This shift could have substantial impact on future congressional and legislature maps, especially for blacks, Hispanics, and other minority voters. In summary, Clarence Thomas' intention is to move the Supreme Court toward a racial neutral approach. That racial neutral is that would sharply limit or eliminate the use of race in voting rights laws, particularly in how legislative districts are drawn, and to reduce the federal role in supervising state elections laws under the VRA. Now, what are Clarence Thomas' main reasons for wanting to weaken the Voting Rights Act? Justice Clarence Thomas' main reason for wanting to weaken the Voting Rights Act center on the belief that its current implication exacerbate rather than eases racial tension. He has argued since 1994 that the VRA, particularly interpreted by the court to require consideration of race-drawing legislative maps actually heightens race division rather than eliminating it. Transforming a remedial law into a tool for racial apportionment, Thomas believed the VRA was originally intended only to eliminate explicit barriers to voting for Black Americans, not to entrench systems that deliberately organize political power along racial lines. He criticizes current laws for having evolved into a device for regulating, rationing, and apportioning political powers among racial and ethnic groups, which he sees as deeply problematic. The person that's problematic is Clarence Thomas, because all these years, over 30 plus years, he's been trying to do this, and my boy just ain't never been Black. And you know, I'd like to see him at a Ku Klux Klan meeting. What, they gonna give him a black hoodie and well, he already wearing a black robe, so they just need to give him
a black hoodie. He'd be like the Clayton, but he's the Clayton Beasby of the court.
Okay. All right. What encourages racially segregated districts? Racial balkanization. He contends that mandating the creation of majority-minority district and prioritizing race, the act leads to what is called consciously segregated districting, fostering a kind of structural and racial separation that distorts the electoral process and fuels division. No, he just don't want Black people to vote. That's the bottom line.
The bottom line, he just don't want Black people and Hispanics to vote. Period. End of story.
That's right. We don't have no rights. And I guess one day they might make him Grand Poobah of the white nationalists, or white clan.
The white nationalists and the white supremacy.
Yeah. So now, it violates constitutional guarantees of equal protection. Now, remember, Amy Coney Barrett said anything that was wrong would be what? Considered as wrong.
Yeah.
Even if it's unconstitutional, and even if it's wrong, you got her vote, because what? That's what she said. Even if it's wrong, and she'll still vote for it. Thomas maintains that the VRA Section 2, in its current form, is in conflict with the Constitution. He argues that requiring or permitting race-conscious districting to ensure minority representation contradicts the principle of race-neutral equal protection enshrined in the 14th Amendment. So there's that word, 14th Amendment, because he's coming for 2, he's taking out 4, and that's how they're trying to get us, and you know, saying we ain't gonna have no rights, and that's what they're coming for, because he's been waiting on this for 30 years to take our rights away. And baby, you know, Trump is doing everything he can to cause this distraction, because this is coming up, and we gotta pay attention. Y'all stay over there with the Epstein. I'll just keep reading about the crew over here, the Hateful Six, because you gotta, are you tired?
No, I'm not tired.
Okay. I had to just stop and ask, because we're sitting on a bench, and you know, I guess his arms are getting tired, so we'll carry on. Now, which draws the court into inherently political questions, political thicket. Thomas is critical of judicial oversight and redistricting, asserting that it forces federal judges to make political decisions about representation. Decisions he believes should be left to the political process, not to the court. He finds it unworkable that courts to attempt to define and measure undiluted voting strengths or fairness in electoral maps. In summary, Thomas' objectives are both constitutional and philosophical. He sees the VRA current interpretation as unconstitutional, politically divisive, and fundamentally at odds with the colorblind legal regime.
You cannot be, there is no such thing as colorblind.
There's that word, racially
neutral and colorblind.
That's them key words that keep us, you know, just saying that, you know what,
there's no such
discrimination. You can't challenge it because of the code words that they're using up there. So, that's just letting you know we're back over here in reality, because this is coming up, and it's coming up on us quick. And like I say, once they hit up 2, they're coming for 14, and that ends it for us.
That ends it.
How
as
does
blacks
Thomas'
in
view on
America.
racial tension relate to his effort to after voting protection? Clarence Thomas' view is that voting rights are protections that requires race-conscious remedies actually worsen racial tension rather than solve them. He argues that when courts and legislation deliberately use race to draw district lines, such as by creating majority-minority district, it creates what he calls consciously segregated districting system. Some more of those words. Thomas believes these arrangements promote division among racial groups and entrench the allocations of political power by race rather than moving toward a society where race is irrelevant to government decision. Because of this, Thomas has pushed for altering, if not dismantling, these voting protections. Where you at, black man spot? Because we just found out that this is not a black man. But you understand what I'm saying? He contends that using race to shape electoral processes enforces and amplifies racial identities in the political sphere. In the words, few devices could be better designed to exacerbate racial tensions than the system created by the current interpretation of the Voting Rights Act. Thomas' efforts to weaken or undo these protections and move toward race neutrality are thus rooted in his belief that only by moving race as a factor in voting right laws can real racial harmony and equal protection under the law be achieved. This ties directly to the opposition to what he views as racial quotes of race bias or race-based government action and other contents as well, such as affirmative action. And he used that, and then what happened? In summary, Thomas' jurisprudence links the persistence of racial tension to the very legal mechanism meant to reduce discrimination, and he seeks to alter voting protection so that the government is not in the business of, as he sees it, dividing electoral along racial lines. And with that being said, if Clarence Thomas ain't an existential threat to
Black America,
black, brown, beige community, I read it for you, because like I said, I can't, it's hard to think about Epstein over there when we got a black man sitting on the bench trying to take us out. Been trying to take us out for 30 plus years, and he's still at it. So that just lets you know where his loyalty lies. And they have never had this much power. The Supreme Court haven't had this much power. And now they're feeling their power, and now they feel like we can overtake them now. We can. But nobody wanted to listen to Harris. Nobody wanted to vote for her. But these are, like I say, elections have consequences. And Thomas has always been a big consequence. And he probably part of the PPP agency too. So in the meantime, this is just, it's devastating. It's, it's terrible thinking about this, because that's what he has planned. And that's what Jasmine Crockett is trying to tell everybody, that they're trying to divide the district so there won't be no representation. So we won't have a say. So, it makes it hard for her to go in and fight for people when, if you got 2 blacks in one district and 125 other people represent, it's a lost cause. And he's steady trying to cut us down. And that's what we need to be out there, talking about, our voting rights, because they coming after them. They coming after 2, then 14. And then you got the biggest, army, military rise army there is, and then what are they going to do? What are they going to do?
Well, what they're going to do is deport us.
Yeah.
That's what's going to happen next.
And Clarence Thomas will finally get what he wants. His black his black Klansmanship pen. He'll finally be a black Ku Klux Klan. But then again, they might serve him up, because if MAGA and the Republicans are eating themselves, if Clarence Thomas didn't deliver, they might say, okay, you done. You've done your duty, so now we're going to eat you up. So good luck, Clarence. And it's sad what you're doing to, you know.
He's a traitor. He is a traitor.
It's sad what you're doing.
The number one
us.
House Negro.
But he is an existential threat by all means. Him, Alito, Justice
Amy Coney Barnett, Kavanaugh, Roberts.
This is all the plan to keep us looking over there at Epstein while they're gutting our right to vote. So on that note,
we are out.